Welcome to our Roadshow recap webinar, which is designed to help members of the profession prepare for the SRA's new approach to regulation. My name is Anthony Townsend. I'm the Chief Executive of the Solicitors Regulation Authority, and I'm going to speak to you for a few minutes about why we're making the changes and the big changes that are coming up in October this year. Let's start by setting the scene. The legal landscape has been transformed by the Legal Services Act. For years there was debate about should the regulatory system for the law be changed, should alternative business structures be introduced. Well, those debates were answered by the Legal Services Act, and we now know that regulation is being transformed, that alternative business structures will be with us later in the year, and it is the job not only of the regulator but of all members of the profession to get ready for those changes and to see how those changes can be used to the advantage of both clients and everybody who provides legal services. There is a booklet which is available on the website called Outcomes Focused Regulation at a Glance, and I would strongly encourage you to have a look at that booklet or visit the web, because that will tell you what the key changes to the new regulatory structure are. You'll see particularly there is a table at paragraph 4.2 of that booklet, which is a guide to getting started with preparing for outcomes-focused regulation. But let me highlight a few things that are changing. First, there is the introduction of what are known in the jargon as COLPs and COFFers. That's compliance officers for legal practice and compliance officers for finance and administration. I'll be talking to you a little bit later about the details of those, but that's one of the things that you will need to think about. Second, the new handbook which we've published, which comes into force on the 6th of October, has a slightly new approach to how to manage conflicts, although the underlying principles behind the management of conflicts have not been fundamentally changed. And then the handbook, and again you can find all this material on our website. The handbook has compensation fund rules and accounts rules, and importantly, some particular requirements about notification and reporting. So do please look at OFR at a glance. As I say, it's the quick way in. It's where you and your practice should start if you're thinking about the preparations that you're going to want to make absolutely sure that you're ready for October 2011. What do you need to do now? Well, I've mentioned COLPs and COFFers, and thinking about the appointments of COLPs and COFFers will be one of the first things on your list. You will also need to think about whether the systems and procedures in your law firm are suitable for the new regime. But let me start with a word of comfort. If you have good systems and procedures now, you won't need to overhaul everything in order to be ready for October. You may need to make some small tweaks. You may want to think about making some further changes, but good systems now should translate very well into our new system of outcomes-focused regulation. You'll need to make sure that your governance and reporting lines within your firm are appropriate. And you might want just to review your management structure. But as I say, there are not great new requirements coming from the SRA which require every practice to start again from scratch. This is about just assuring yourselves that what you have is fit for purpose. At the SRA, we are committed to making sure that you have appropriate guidance and tools to help you to prepare for the new regime. I've already mentioned the handbook. The handbook is online, it's free to use, it's very searchable. The Law Society is publishing a hard copy, which of course you are welcome to buy, but you can see free online the new handbook now, and you can start to get familiar, particularly with the new Code of Conduct. And one of the things that you will see in the new Code of Conduct is that it is much, much shorter than the existing Code of Conduct. And I'll talk a little bit more about that in a moment. I've mentioned the booklet OFR at a Glance, again available on the web, a quick guide to the kinds of preparations that you will need to make. And then we're running a series of webinars, of which this is one, designed to help you and your colleagues think about preparations and indeed to ask us questions to make sure that you're ready for October 2011. The first thing I want to say about the new regime is that the principles which underpin the new Code of Conduct are familiar, and they are based upon the ethical principles that all solicitors are already trained in. The first 6 of the new principles are particularly familiar. You are required to uphold the rule of law and the proper administration of justice. You're required to act with integrity. You must not allow your independence to be compromised. You must act in the best interests of each client, provide a proper standard of service to those clients, and behave in a way that maintains the trust the public places in you and in the provision of legal services. I don't think there is anything contentious in any of those principles, and it enables me to make a key point about the new Code of Conduct. Nothing to do with the regulation of solicitors or the way in which you have been practicing is being watered down. We are not diluting the ethical professional principles of the profession. Indeed, the new Code of Conduct is designed to enable you to continue to uphold those high standards, but giving you a little bit more flexibility in the way in which you deliver those standards. Some people have called the new Code of Conduct dumbing down. We say that actually it is a more adult form of regulation. It is a form of regulation which rightly places the individual professional in the position to make judgments about what is best in the public interest and the interests of clients. The 4 principles which follow the first 6 and make up the full set of 10 are slightly more technical but nonetheless very important. You are required to comply with your legal and regulatory obligations and deal with your regulators and ombudsman in an open, timely and cooperative manner. Part of being in a regulated profession is cooperating with the regulator, and in turn we will do our utmost to interact with you in a way which is prompt, professional and courteous. The second thing you are required to do is to run your business and carry out your role in the business effectively and in accordance with proper governance and sound financial and risk management principles. Many of the problems that cause damage to clients and many of the problems that cause the SRA to intervene and spend money result from problems in the running of law firms. And therefore we are putting an emphasis upon the importance of making sure that law firms are properly and soundly run to prevent problems arising later on. Very importantly, there is a requirement, the 10th principle, to protect client money and assets. Again, harm to clients in its most acute form often occurs when client money and assets are not protected, and therefore we are placing a very high premium on the importance of protecting client money. The new Code of Conduct, which I urge you to look at, is all structured around those 10 principles. But beneath each of those 10 principles, there is a framework divided into what we call outcomes and indicative behaviours. First, the outcomes. The outcomes are mandatory. You must produce the outcomes, and we have put the outcomes in to give you appropriate guidance on the things that must happen if you are to abide by the principles. The second element are the indicative behaviours. These are optional, but they are designed to give you indicators of the kinds of things that we in the SRA will expect to see if for any reason we make inquiries of your practice or come on a visit. As I say, they're not compulsory. You may find that with your client base and with the way that you run your business, you can actually abide by the principles and produce the outcomes in a different way. And so long as you can justify that to us, we will be very happy with the position. One of the most important things to stress about outcomes-focused regulation and the new form of regulation that we're trying to deliver is that it is based upon the presumption that the vast majority of solicitors are highly educated, intelligent, ethical people who are in the best possible position to work out what it is proper to do. As a regulator, of course, ultimately we may have to hold you to account, but the new code of conduct is designed to give you more flexibility so that you are not bound by what are sometimes called pettifogging rules. To give you an example of that, where previously in the current code of conduct we've required things like written policies, equality and diversity being one example, or we've been very prescriptive on things like client care letters, you will see that in the new handbook we give you much more discretion. The extent to which you want to exercise that discretion is up to you. The indicative behaviours are, if you like, a way in which you can play safe, but we hope that many firms, particularly in the new competitive market, which will be opening up when alternative business structures are introduced, we hope that many firms will take advantage of this flexibility, which will be good for their clients and also good for their businesses. A word or two about risk management and compliance. One of the principles behind this new regime of outcomes-focused regulation is a new and constructive relationship between the SRA and those it regulates. We want to see as much as possible of the risks which inevitably arise in legal practice being managed by law firms and practitioners rather than the SRA having to come in to deal with risks after they've arisen. The new regime that we are introducing includes a concept called supervision, and that will be about promoting constructive engagement with law firms so that we can ask you if particular risks arise and you can explain to us how you're going to deal with them. We want to reserve formal enforcement only for those cases where a law firm or an individual either cannot or will not cooperate. Wherever possible, we want to use informal means for dealing with risks and putting people right. I've mentioned about compliance officers for legal practice and compliance officers for finance and administration. A word or two about these new roles. These are being introduced to make sure that in every law firm there are individuals who are keeping an eye on and making sure that compliance takes place. I need to make it clear that these two roles are not designed to place all responsibility on the two individuals. On the contrary, those managing firms and individuals within the firms will continue to be individually accountable for what they do. But the compliance officer for legal practice and the compliance officer for finance and administration will play very important roles in ensuring that each law firm is taking sensible steps to manage its own risks. The compliance officer for legal practice, who essentially will be looking at compliance with the code as a whole, that compliance officer has to be a lawyer. The compliance officer for finance and administration does not need to be a lawyer. But we've made the requirement very flexible. You could, for example, have one person combining both roles. You could choose to make a partner the culp and or the coffer, or you could choose to have someone below partnership level if they had sufficient seniority to undertake the roles. As a sole practitioner, you could choose to be the culp and coffer yourself. So there is plenty of flexibility in the system, but we are keen to make sure that there are individuals within each firm that we regulate to whom we can come and ask questions and assure ourselves that risks are being properly managed. The COLPs and the COFFers will be subject to a suitability test, and there are requirements that by the 31st of March next year, you will need to have nominated COLPs and COFFers to us, so that by the 1st of October 2012, when the new system comes into place, you have an approved COLP and COFFer in your firm. A word or two now about alternative business structures, the new kind of law firm that the Legal Services Act is enabling and which we expect, subject to parliamentary approval, to be introduced from October. We have spent a lot of time making sure that alternative business structures are regulated in a very similar way to traditional law firms, and in particular that they have to abide by exactly the same ethical principles as traditional law firms. There is no question of having different standards for alternative business structures as distinct from traditional law firms. We've also been very careful to make sure that the regime for alternative business structures protects the compensation funds so that, for example, if an alternative business structure is undertaking non-legal activities, there can be no question of the compensation fund having to bail out those non-legal activities. We have also put in provisions to make sure that any external owner of alternative business structures is properly vetted to the same kinds of standards of probity that we require of solicitors. So it is a very tough regime for alternative business structures to make sure that they do not pose unacceptable risks. At the SRA, we are committed to transforming ourselves in order to introduce outcomes-focused regulation in a way which protects clients in the best possible way, but also makes it as easy as possible for those whom we regulate to relate to us. We're doing a lot of work to improve our cost effectiveness. The numbers of staff in the organisation are reducing. We are in the middle of replacing very expensive and out-of-date IT systems, which will enable us to make further efficiencies. So we are committed to making sure that the new regime is more efficient and more cost-effective, and therefore decreases the burden upon those we regulate. We're restructuring our operation around three core functions: authorization, supervision and enforcement. And very briefly, what that means is that at the authorization points, we are going to be tougher in making sure that we don't let the wrong people or dodgy firms into the regulated environment. And we will be spending a lot of time in our supervision function talking to firms, dealing informally with firms, and trying to make sure that we don't have to move to formal enforcement if we can avoid it. We do, of course, have to retain an enforcement function because, sadly, there will always be people who are either fundamentally dishonest or who simply can't cope, and for whom the only means of obtaining public protection is through formal enforcement. That gives you a flavour of the main changes that are coming in the new regime. Following the presentation that I've just given, there will be 3 sessions in this webinar. One is on the Handbook, which will give you further practical examples of the changes that the new Handbook will bring, and will also talk in more detail about the role of the COLP and the COFFer. There is a session on authorization, which will explain to you how to set up a new firm, and also, if you're interested, how to set up an alternative business structure. And it's worth saying that alternative business structures may prove to be an opportunity for small firms in the high street, as well as for larger entities of the kind that the media have been covering. So do take a look at that. And finally, there will be a session on supervision. That is designed to explain to you how your relationship with the SRA may change as a result of the new regime and the kinds of ways that you can interact with us in the future.
My name's Nikki Taylor, and I'm going to build on what Anthony's just said to help you get started with the SRA's new handbook. I'm a member of the SRA's team which drafted the handbook, and I've worked on the consultations and the policy development leading up to the handbook. First, a bit of personal background. I'm a solicitor and I've worked both in private practice and in-house. I've had extensive experience of legal regulation, having worked both for the Law Society and the SRA on a variety of roles, including policy development, supervision and enforcement. So, here's a summary of our session on the handbook. First, I'll take a quick look at what's different about the new handbook as compared with our current regulatory approach. Next, I'll give you an overview of the handbook, what's in the various sections of it, so you can navigate your way and find the particular thing you're looking for. Then we'll shine the spotlight on the 10 principles which, as Anthony has just explained, are absolutely crucial since they underpin the whole structure. We'll take a look at a couple of examples of how the new Code of Conduct, which is part of the handbook, applies our outcomes-focused approach to regulation. Next, we'll focus a little more on the new OFR mindset and how firms and individuals should approach the management of risk. We'll then look at the two new key compliance roles, the cold and the copper, which all firms, including sole practitioners, will need to think about filling. Then we'll briefly review how the handbook deals with some key issues, and I'll show you a couple of case studies for you to think about. And finally, I'll be asking you for some feedback and to help us help us in giving you, the regulated community, some support as we move towards the new handbook coming into force in October. So, what's different about the handbook as compared with the current system of regulating legal services? Well, quite a lot. The new SRA handbook brings together in one place all the regulatory requirements that apply to everyone we regulate, including sole practices, traditional firms, in-house practice, and the new ABSs, which of course include non-lawyer owners and managers. Our intention is that clients of all types of legal practice receive the same level of protection. So we have a stop press item here. The Legal Services Board, the LSB, our overarching regulator, has recently given us a thumbs up for the handbook. We expect it to come into force on 6 October, and please visit our website and start to become familiar with the new handbook. So we expect the handbook to come into force and go live in time for it to apply to both traditional forms of practice and to ABSs. We've explained that we aim that all types of legal practice which we regulate should receive the same level of protection. But please note that the exact timing is still subject to the parliamentary timetable, so keep an eye on our website for updates. What else is different about the new handbook? First, the draft handbook has been available on our website since early April. So, as I've said before, please take a look at it if you haven't already managed to do so, and get familiar with how it works. You can be sure that our online version of the handbook is the authoritative source for all the SRA's regulatory requirements, and we plan to update it regularly. You will be able, in due course, to download it, the whole thing or specific parts of it, as PDF files. So you'll eventually be able to carry it around with you if you want to, for instance on your iPad or your Kindle. If, on the other hand, you prefer as well, or instead of having a portable electronic handbook, to have a more traditional book format, then the Law Society plans to publish a paper version in due course. We at the SRA are keen to support you in making the transition to the new handbook and OFR, and this slide mentions some of the sources of help which we've got available for you. As Anthony has already mentioned, OFR at a glance is there on our website. It's got a lot of information, advice and help, and I strongly recommend that you take a good look at it. So, moving on, let's now take a closer look at the handbook and do some navigation through its structure. The new handbook is made up of the following sections. First and foremost, we have the 10 SRA principles, and these are absolutely fundamental to the handbook and to OFR. Please look at those in more detail with me shortly. Next, we have the SRA Code of Conduct. This is very different from the current 2007 code. Rather than containing prescriptive rules supported by guidance, it contains mandatory outcomes and non-mandatory indicative behaviours. And as Anthony has mentioned, but I think it's worth emphasising, the outcomes describe what you're expected to achieve in order to comply with the principles in specific contexts set out in the chapters in the code. And the indicative behaviours are examples of the kind of behaviours which may establish whether you've achieved the outcomes and complied with the principles. The code provides clarity for consumers about the outcomes and protections that they can expect. So, the next section is the accounts rules. These are the rules for the protection of client money, including new outcome-focused provisions on authorising withdrawals from client accounts and accounting for interest. They therefore provide some operational flexibility for firms. Now, moving on, there's the section on authorisation and practicing requirements. This sets out our new approach to the authorisation of firms, including sole practitioners and ABSs. Appointing compliance officers, that's the Colt and Coffler again, and we'll be looking closer at these roles a little later. Then there's notification requirements, admission requirements, and provisions concerning education and training. The client care section contains new outcomes and rules concerning professional indemnity insurance and the compensation fund. This is followed by the discipline and cost recovery section, which includes our new approach to fining and disciplining firms and individuals. And my colleague Andy will be telling you a little bit more about that in a little while. Next, there's the specialist services section, with provisions for firms offering financial services and property selling services, and requirements concerning cross-border activities in Europe. And finally, there's the glossary. Now, the glossary will be the one single source of definitions for terms used throughout the whole handbook. It's still being developed and refined, and so for the time being, each set of the rules which comprise the handbook contains their own definitions. We're planning to make the glossary really user-friendly in the online handbook, where you can place your cursor over a defined term, which will be shown in italics, and the definition will instantly be displayed. So, that's the structure of the handbook, and so now let's take a closer look at the 10 principles. The 10 SRA principles lie at the very heart of the new structure. They embody the new ethos of OFR, and they also reflect, as Anthony mentioned, the traditional core values of solicitors. We expect you to act in accordance with the principles in everything you do, and you need to use them as the basis for all your decision making. The first 6 principles will be very familiar to you. You've already heard Anthony talk about them in his session, and I won't dwell on these 2 slides which set out principles 1 to 6. So there's principles 1 to 6. And so moving on to the remaining principles, let's take a longer look at the 4 new principles, that principles 7 to 10. And you'll notice that although the values which principles 7 to 10 express are not expressed as principles in the current 2007 code, they're all central to the delivery of OFR and to client protection. So the content of these new principles will be familiar. So let's have a closer look at principle 7. So you must comply with your legal and regulatory obligations and deal with your regulators and ombudsman in an open, timely and cooperative manner. So you should, for example, comply with the reporting and notification requirements and respond fully to communications we need information about a firm in order to assess risk, and this is a central plank of OFR. And you'll be hearing a bit more about risk and how we'll be using it from my colleagues in a little while. Principle 8 says you must run your business or carry out your role in the business effectively and in accordance with proper governance and sound financial and risk management principles. So whether you're a manager or an employee, you have a part to play in helping to ensure that your business is run for the benefit of clients. For example, meeting the outcomes in Chapter 7 of the Code about the management of your business. This again supports OFR and the assessment of risk by stock firms. Now let's move on to the final two principles, 9 and 10. Principle 9 says you must run your business or carry out your role in the business in a way that encourages equality of opportunity and respect for diversity. So again, whether you're a manager or an employee, you have a role to play in achieving outcomes in Chapter 2 of the Code, which is about your clients and equality and diversity. And then finally, Principle 10, you must protect clients' money and assets. This principle goes to the heart of acting in the best interest of your clients. You must play your part in, for instance, protecting property belonging to your clients. Now, a brief word about enforcement. Our approach to enforcement is proportionate, outcomes-focused and risk-based. Therefore, how we deal with any failure to comply with the principles will depend on all the circumstances. Our aim will be to ensure that the right outcomes for clients are achieved and to protect the wider public interest. You'll be hearing more about our approach to enforcement from Andy in a little while. So, those are the all-important principles. Now let's look at the OFR mindset, a different way of thinking. So I want to look briefly at a couple of examples from the Code of Conduct in the Handbook, which will show you what's different about the OFR approach. It's important to remember that responsibility for meeting requirements in the Handbook and for operating effective systems and processes within a practice lies with you. You'll see we've stripped out of the Code much of the detail which is currently in the 2007 Code. This is to empower you to implement the right systems and controls which are fit for your particular clients and your particular type of practice. You'll have more flexibility and can use your judgment. So you need to get used to the different way of thinking, just as we need to. So here is an example applying our approach to help you get into the new OFR mindset. So let's look at the slide. It compares the old and new requirements for reporting, and we'll see that the old approach, Rule 20 of the 2007 Code of Conduct, contains reporting requirements on limited areas. Now, contrast this with the Handbook approach, new Rule 7 on cooperating with regulators and ombudsmen. The outcomes on reporting require you to engage with the SRA in an open and constructive manner to enable the SRA to respond proportionately. Now, other examples from the code of the new OFR mindset can be seen particularly in the areas of client care and the management of your business. Which leads us on to risk management by firm, a different way of operating. I'll start by saying that firms that are already well managed and provide a proper service to clients have nothing to fear from the outcomes-focused regulatory approach. We'll encourage you to identify, manage and mitigate any risks to your ability to meet the requirements in the Handbook. We expect you to be forward-thinking and able to identify emerging risks. For example, have you thought about succession planning? This is, after all, just good business practice. When thinking about your firm's compliance with the Handbook, take a look at Section 5 of Outcomes-Focused Regulation at a glance. This suggests some questions you might like to ask yourself when considering whether you have effective compliance arrangements in place. So, for example, does the type of work you do pose particular risks? to meeting the handbook requirements. So here's a flow chart which might help you get started if you think you need a little bit of help. And it's reproduced in that much mentioned bit of guidance, OFR to glance. So I appreciate that the print is a little bit small there, but I do urge you to go and have a look at it in OFR to glance. So in identifying and managing risk, it's for you to decide on the form that your systems and controls take, bearing in mind your particular practice, the area of work you undertake, and the people who work in your practice, and the particular needs of your clients. Consider how you identify and manage and mitigate any risks. You can then look to ensure that your systems, controls and policies are effective. So, for example, you should ask, are risk and compliance issues regularly monitored? Now, let's move on and look at Colts and coffers in a little more detail. The SRA authorization rules contain requirements that mean that ultimately all firms which we authorize will need to appoint compliance officers for legal practice and for finance and administration, the Colt and the coffer. Risk management and proper governance of firms for the ultimate protection of clients is at the heart of these roles. For a quick summary of the roles, including answers to questions such as what do Colts and coffers do and who can be appointed as a Colt and coffer, please again refer to OFR to glance. We'll be running a webinar devoted to the roles of Colts and coffers on the 7th of July, so please join us if you can, and we encourage you to take part. But briefly, these compliance officers, who can be employees but must have sufficient authority for their roles, ensure that the firm complies with regulatory requirements, record failures to do so, and report to the SRA material failures. So let's take a look at planning. You'll need to decide, for example, who you're going to appoint as a Colt and coffer in your firm. How will the Colt and coffer operate within your particular business structure? What systems are needed to support the roles? And will you need to change your governance and reporting lines? And how will you review the efficiency and effectiveness of the Colt and coffer? Now, the next slide contains the details of notification and information requirements which appear throughout the handbook. It's really a sort of a reference. I'm going to mention one or two key updates. For more details, have a look at OFR at a glance. But the following two slides highlight some of the key issues and how these are dealt with in the handbook. Unfortunately, we don't have a great deal of time in this webinar to go into the details, but I do recommend that you check the position in the handbook and as I said, take a look at OFR at a glance. So the key areas are in the region of acting for buyer and seller of land, acting for lender and borrower, and then there are referral arrangements. Other key areas are client care, complaints handling, and something which has come up fairly recently, outsourcing. And do have a look as to how these issues are dealt with in the handbook. Now we're moving on to a couple of case studies, and perhaps I should explain, during the roadshows, obviously we were able to have a more sort of interactive sessions. So we're trying to give you a taste of the roadshow here. Let's just have a quick look at the case studies, and what I suggest you do maybe is talk with your colleagues afterwards to work out what sort of approach you might take. So the first case study deals with the duty of a coffer. You're a coffer in a small three-partner firm. You're an employee and not a manager of the firm. The cashier tells you that invoices are unpaid because the firm has exceeded its overdraft limit. You learn that the overdraft facility has been extended on a number of occasions, and the bank's now refusing to extend it again. Your managing partner tells you that this is a temporary cash flow problem and that there's no necessity to report the matter to the SRA. Now, the question is, what should the COFA do about it? The next slide suggests some questions that the COFA might like to think about, and I hope that that will be a useful basis for your discussion. Okay, let's move on to our second case study, and this is all about co-defendants. You act as the two co-defendants charged with assault. To begin with, their stories are consistent. However, one of the defendants is concerned that he might receive a custodial sentence because he's got past convictions. He changes his story to blame his co-defendant. The co-defendant is a long-standing client of your firm. So the question is, can you continue to represent both or either of these clients? I think this must be a fairly common dilemma for firms who work in criminal matters. And again, the next slide gives some pointers to help decide how to deal with an ethical dilemma. And again, I do suggest that you have a look at how you might apply the outcomes, principles, and the indicative behaviours to help you resolve and decide on the appropriate course of action. So, moving on, we'll take a short break for a question. I want to say that we really value your feedback, and we're keen to help you in getting ready for OFR and the new handbook. But we want to hear what you make of the help that we're providing to you, and whether you do actually find it helpful. You've heard mentioned several times already, and you'll probably hear it mentioned later on by my colleagues, the document which is on our website, Outcomes-Focused Regulation at a Glance, your quick guide to getting started with OFR and the new handbook. Now, we'd be grateful if you'd let us know by voting yes, no, or maybe I haven't had time to look at the document yet, whether you actually do find it helpful. So, could you please vote by using the buttons now, please? Right. Well, this is really very, very encouraging, because what we're seeing here is that those who have looked at it find it helpful. We haven't got anybody, or hardly anyone, saying that they don't find it helpful, and yeah, many of you haven't had a chance to look at it yet. Well, that is understandable. We're all very busy people, but I think what I would say, if you haven't had a chance to look at it yet, we do recommend that you check it out as soon as you can and draw it to the attention of your colleagues. Okay, I think we can leave that there. So just then, looking at our final slide, this is a summary of the tools that we have available to help you. The SRA website has a full list of the webinars, and it has recordings of previous webinars that you can listen to. I'd also mention that the ethics helpline is there for you, and My SRA, you'll see mentioned, it's being introduced to replace our paper-based system of application forms and fees, payment. You'll be provided with a unique username and password to access your own SRA online account. Okay, now I'm going to hand over to my friend and colleague, Anne Morgan, who will explain about the authorization of firms and role holders with a particular focus on ABSs. Over to you, Anne.
Thank you, Nikki. Good afternoon. As Nikki said, my name is Anne Morgan, and I'm the ABS manager here at the SRA. I lead a small team of people implementing process and procedure to enable the SRA to authorise and regulate ABS firms. So let me now introduce you to the authorisation function. Authorisation is an important part of the structure going forward at the SRA. Much of what is currently done by the operations function now will form part of authorisation going forward. For example, PC renewals, ABS applications, student applications and admissions. In fact, there's over 60 different types of applications that authorisations will deal with. In particular, authorisations will be responsible for dealing with the Culp and Copper nominations that Nikki has mentioned. We will be communicating the process about how you can go about nominating in the autumn of this year, and nominations need to start taking place in January 2012 so that we have the nominations completed by March 2012. We will also administer the new suitability test. So the suitability test replaces the old character and suitability guidelines and now forms part of the handbook. We have to ensure that any individual entering the legal profession has and maintains the level of honesty and integrity and professionalism expected by the public, other stakeholders and professionals, and does not pose a risk to the public or the profession. The test is the same for non-solicitors, as they will be working within the profession and must meet the same high standards that the general public expects of solicitors. The test itself will apply to students, those seeking admission to the profession, applicants for the QLTS process, compliance officers, owners and managers. New questions are currently being added to the application forms that you would see, and we will undertake validation exercises of the information that we are given. One of the tools we'll use to validate this information will be vetting. This is a method of background checking which will give us the ability to search international and UK-based databases and is vital in respect of ABS applications. We will be using third-party providers to search publicly available databases for information, and we will also continue to undertake CRB checks on all new entrants to the profession. Where the information from these checks informs our decisions, we will make the information available to applicants and candidates. Now let me move on to our online application. This is how authorisations will be able to deliver a good service to you in the future. We launched our first online application earlier this year for student admission. So far we've processed over 400 applications, and over 70% of those applications have received automated decisions. Subsequent phases of the online applications will commence this summer, with most applications going online by October 2011. We would like to emphasise that we expect all of our interaction with you to be online for the purposes of application. The only exceptions will be by application for reasonable adjustments. The benefits to you of the online world will be the ability to track your applications with us online, no more having to chase around the SRA to find out what's happening with that application or PC renewal. Payments will be via secure online facilities, BACS, CHAPS, credit and debit cards. All this will save you and us time. Now the next slide shows you a picture of what My SRA currently looks like on our website. There has also been a webinar covering the features of My SRA in detail, and you can find the slides and the audio for this on www.sra.org.uk/webinars. Shortly you'll be receiving both individual and firm log-on instructions, and this should start to take place from July. We encourage you to log on as soon as you receive this information to set up your own secure login and password information. You will also be able to check and, if necessary, amend the information we hold about you or your firm. This is important, as the data will be used in the future to pre-populate any applications that you make to us, in particular the forthcoming PC renewal exercise. So just to recap on the benefits of our online facility, there'll be access to a secure portal with secure online payment facilities, improvements in overall efficiency with many decisions being made instantly without the need for waiting. There will be significant cost savings at the SRA, which ultimately we hope to pass on to the profession in the reduction in cost of regulation. And there's the ability for you to be in control of the information that the SRA holds about you, so you can update that as and when is necessary. So that sort of gives you an overview of where we are with authorisation and how you'll interact with authorisation as a function going forward. But let's move on to alternative business structures. By way of background, we're introducing alternative business structures as a result of changes in the legal services market that Anthony has already covered. We do want to stress that we feel that it's important both the Law Society and the SRA should become a licensing authority to ensure that there is consistent treatment of both recognised and licensed bodies. Our licensing authority application has now been approved by the LSB, and we are now dependent on the parliamentary timetable for our designation as a licensing authority. We are still hopeful and working to a summer designation date, with the first licences being granted in autumn of this year. So who does need to be authorised? Well, it's any entity that wants to offer one or more of the reserved legal activities. And by that we mean the rights of audience, the conduct of litigation, reserved instrument activities, probate activities, administration of oaths, and the provisions of immigration advice and services. There are a couple of exceptions, and those relate to special bodies in particular, as the sections of the Act applicable to special bodies, independent trade unions, not-for-profit bodies, etc., do not come into force until 2013. There are also an exemption around legal services bodies. If there is any very small indirect involvement by a corporate entity that contains non-lawyers, this may mean it is a legal services body but not a licensed body. So what are the requirements for a licensable body? Well, essentially, they're very simple. The body needs to have one lawyer manager, one non-lawyer manager, and must, as I've already mentioned, offer a reserved legal activity. So what can you do to prepare to be an ABS? Well, in particular, and as Nikki has already stressed, there is the need to become familiar with the new handbook, in particular the principles, the code, and the authorisation rules are key to how the authorisation process will work for new ABSs. If you're a new ABS, you'll need to consider which of the reserved legal activities you will offer. This will form part of the information we ask on the application form and will also appear on your licence once it's granted. In addition, you will need to consider whether you need to undertake any business planning activity. Those of you who are considering ABS who are currently recognised bodies may feel there's no need to go into an excessive amount of business planning. However, those new organisations considering alternative business structures might need to do considerable amounts of business planning to establish what their strategy is and their growth over the next few years. As part of the application process, we will expect to be able to be given information about estimated turnover, profit and loss and cash flow, as well as your growth plans. You can consider your governance structure, particularly the position of the compliance officers, which, as Nikki has already said, and Anthony before, that these are key to the way in which we intend to regulate the businesses going forward. So moving on specifically to compliance officers. The next two slides set out what a compliance officer needs to be and the type of role that they have, which has already been covered extensively by Nikki. But just to re-emphasise, the compliance officers within the organisation are a very important part of the self-regulatory approach that supports OFR. Both the compliance officers can be managers or employees, and they must be of sufficient seniority. In particular, from an ABS perspective, they cannot be disqualified as a HOP or a HOFFER under the LSB's requirements. In particular as well, to point out that the COFFER does not need to be a qualified accountant. However, we will be looking at experience of those compliance officers, finance administration, to ensure that they do have the requisite experience to carry out the role. So what steps can you take now? Well, you can most certainly read the guidance on the SRA website, which can be found in the Freedom in Practice section of the website under ABS guidance. This details out exactly what a recognised body today can do in compliance with the current code in order to move towards an ABS structure. But particularly, you can discuss options with potential business partners, explore non-binding arrangements, register company names, agree to enter into exclusive negotiations, and consider whether or not becoming a legal disciplinary practice might also be a possibility for you. Finally, moving on to legal disciplinary practices with non-lawyer managers. The Act and our rules allow for a 12-month transition period for these firms as they are a type of ABS. From the point that the SRA is designated in August 2011, an LDP with non-lawyer managers can elect to become an ABS, and this will be a shorter process than new ABS firms applying to the SRA. Alternatively, firms can wait until the 31st of October 2012 when they will be passported if the non-lawyer element of the structure remains into the ABS regime. Regardless though, all firms, LDPs and traditional recognised bodies must apply for approval of a designated Culp and Coffer by the 31st of March 2012. And that concludes the presentation around authorisation and alternative business structures. And now I'd like to hand over to my colleagues from Supervision, Risk and Enforcement, Amanda, Martin and Andy, to take you through the final part of this presentation.
Thanks very much, Anne. Good afternoon, everybody. I'm Amanda Norton and I'm a Relationship Manager at the SRA. You'll hear more about relationship management in the supervision section of this workshop later. I'm a chartered accountant and I've been at the SRA for 14 years, which I think goes some way to explain that terrible photograph that you're looking at there on your screen. I'll be talking to you about the SRA's approach to risk this afternoon, and then Martin will be talking about supervision, and Andy will be outlining the SRA's approach to enforcement under OFR. At the end, we have an example that draws together the three areas of risk, supervision and enforcement with an illustration of how the approach will work in practice in the future. So let's move on to look at risk from the SRA's perspective. So what is risk-based regulation? Well, what you can see here on the screen is a rather theoretical definition from Professor Julia Black. Perhaps a more pragmatic definition of how the SRA views risk-based regulation is deciding which risks we can do something about and targeting our limited resources to the greatest risks or to those that can be mitigated by regulatory intervention. And I think it's really important to stress that the SRA does have limited resources, and we need to recognise that the SRA will not be able to actively mitigate all risks. So we'll focus our attention on those areas that we think we can do something about. Now, when we're talking about risk in this workshop, we mean the risk to the SRA achieving our objectives as a regulator. And these are the objectives that are set out for us in the Legal Services Act. And just in case you can't immediately recall what they are, I'll set them out for you now. So our regulatory objectives are to benefit the public interest, to support the rule of law, improve access to justice, benefit consumers' interests, promote competition, encourage an independent, strong, diverse and effective legal profession, increase understanding of legal rights and duties, and lastly, you'll be glad to hear, promote adherence to the professional principles set out in the Legal Services Act. And I'm sure that you'll be able to recognise that many of these objectives are reflected in the principles you've heard about from Anthony and Nikki already this afternoon. And also to explain that the SRA will be assessing risk as a function of the impact on our objectives and probability of the issues arising. We're developing our risk centre and are starting with relatively unsophisticated assessments of firms, which will evolve over time. So it's likely that our initial assessments will be fairly broad brush and are likely to categorise firms as high, medium or low impact. I'll talk about impact in a moment in more detail. It's likely that over time we may ask for more detail from you and your firms, but for the moment we're keeping it simple. So for 2011, you're likely to be asked for the same sort of information as you were last year, with some additional information on complaints that you received. In dealing with risk, we'll be looking at the impact of firms, as well as risk themes, such as conveyancing, which could operate across the whole profession, and also at operational risk, which is caused by the SRA's own internal operations. For example, if we apply an inappropriate risk categorisation to a firm. We are very keen to share our analysis with you, so we're looking at how that can best be achieved. For example, we recently published a piece in the SRA update on ID fraud of firms, where firms' identities were hijacked and copy websites created to make it look as though that was the firm's actual website. Now, if you have any thoughts on how risk information can best be shared, then the risk team would be very pleased to hear from you and would be grateful to receive any of your thoughts through the email that's available on the Freedom in Practice website, which is part of the SRA's website. Okay, if we move on to talk now about how we use risk. Sorry, I think the slides have got slightly out of order. Could go back now. How we can use risk. Okay, I think the most important thing that I'd like to emphasise is that we are using our assessment of risk to inform our supervisory approach and to direct our limited resources. Risk for the SRA is a function of the impact on our objectives and the probability of the issues arising. The impact of a firm is assessed on the size of the firm, with some sense checking around the amount of money held and the vulnerability of the client base. This doesn't mean that a high-impact firm is a bad firm, just that should something go wrong with that firm, it will have more of an impact on our ability to meet our regulatory objectives. We expect that most smaller firms will be medium or low impact. Larger firms are likely to be assessed as high impact because, for example, if a large firm fails, the cost to the SRA of intervening into that firm would be very considerable. It's also worth stressing here that the SRA impact assessment is different to the risk assessment process carried out by insurers. The SRA is looking at risks to our regulatory objectives, while insurers look at the risk of claims being made against firms and the risk of paying out against those claims. Our experience in the relationship management pilot is that many high-impact firms appear well-run with low levels of complaints and good risk and compliance mechanisms. And the way in which we have supervised firms assessed as high, medium and low impact will be covered by Martin in a moment. Our own SRA operations can cause risks to achieving regulatory objectives, but they'll be considered apart from the risks in firms or the legal services market. Now, talking about thematic risks, we anticipate that in the early days, especially as the SRA risk framework evolves in sophistication and range, the SRA moves to OFR and the market changes, this will be where we deploy significant resources. We believe strongly that a multidisciplinary approach will be important to looking at thematic risks, but themes will not be driven by a disciplinary mindset. The aim is likely to be educative or to mitigate a particular risk, rather than to discipline a group of firms identified within a theme. And this is a really good example of the SRA's move to being a proactive rather than a reactive regulator. That's not to say, of course, that events will no longer matter. Events will sometimes be high risk and will demand immediate action. We're not a complaints handling body any longer, but we will still react to reported events when we need to. And we already have a risk assessment framework for events, which is the Risk Assessment and Designation Centre. If you're interested in how that works, you can have a look at it on our website. And we will be looking to build on the successes of this approach. So thank you very much for listening to me. Hopefully you now have a better understanding of how the SRA will assess firms for impact and its approach to risk. And I'll pass you over to Martin to hear how the risk approach will be applied in the SRA's approach to supervision.
Many thanks, Amanda. I'm Martin Jordan. I'm a relationship manager, as is Amanda, and also I'm an accountant. And I'll explain later why you've got accountants sitting in the relationship management team. But first of all, I think the main thing is the impact of OFR. As we've already heard, the move to the new handbook signals a change of emphasis from prescriptive rules to the achieving of broad principles, giving the firm the freedom to achieve compliance with these principles in a way that is appropriate to themselves. Outcomes-focused regulation also allows us as regulators to get to know and importantly understand individual firms. As I say, I've been with the SRA for 17 years, and continually over that period, one of the criticisms that's come back from the profession is, well, it's all very well you saying that, but you don't understand what we're about. Well, this is our attempt and to move that forward and to get to know and understand firms. And whenever we look at problems, we will be doing it from a background of knowing the firm. Well, what is supervision under OFR? Amanda has already highlighted the importance that risk plays in OFR. and how it will drive the supervision function. By the concentration of risk, the SRA will not only reduce the regulatory risks to itself, but help the firms to mitigate their own risks in practice. It also enables the SRA to target resources effectively to the areas where it is most needed, which not only means that the profession will get better value for money, but individual compliant firms should notice a lesser amount of regulatory input. And again, another criticism has been that there's been too much focus by the SRA on small, fiddling little rules. I think Anthony mentioned it in his talk, that we need to concentrate on the big events. So how are we going to do this? Well, I shall now go through the various supervisory tools that we should be employing to address these various risks. But first of all, I think we need to look at what a good regulation looks like. The current move to AFR has its roots set in a report commissioned in 2005 by the then Chancellor, by Philip Hampton, and in which he sets out the basis that regulation should be based upon the risks to the regulator, not on a one-size-fits-all. Again, another criticism that's been levelled at us. But the new approach aims to give a different approach to every firm that is regulated by the SRA. Following on from this, articles by Julia Back has expanded on the basis of what good regulation should look like, and one of the conclusions was that it should include an element of random inspection. When I come to some of the what goes on in the various risk categories, random inspection will be mentioned then. But the common thread to all these papers was that the firm should only be supervised by appropriate persons who understand the firm's business model. We've already found in the relationship management pilot, which I'll be discussing later, that there is a knowledge within the SRA that both Amanda and I have got on finance that has been a great asset to help understand the financial stability of firms. So the society has gone out of its way to bring together people who can best react together as a team to help supervise individual firms. The SRA's way of supervising is to encourage firms to identify and tackle risks, to mitigate against them or to remove them entirely if it's all possible. By doing this, as well as moving to the new handbook, firms should improve the standard of practice for their clients and help provide the required outcomes. Well, how will supervision operate with the different approaches? Well, there are three types that I'm going to talk about today, and they're interwoven into the various impact ratings. But the first is what I'm involved in, and so is Amanda, is relationship management. And then there's an element of desk-based supervision, and there's going to be visits to firms. So it's not a one-size-fits-all process, but will involve a variety of proactive approaches. Now, turning to the high impact. Amanda has already told us that the impact rating of a firm will dictate what type of supervisory tool will be used. For those that are rated as high impact, the tool that will be used is that of relationship management. Now, Amanda and I have been seconded for a number of months to the relationship management department and are engaged in the pilot, which is running from September 2010 and will conclude in July. We're engaging with 19 firms within the pilot, and these range from sole practitioners through to the biggest global practices that there are. But also encompassed in this, the selection that we've got are a number of unusual business models, and we're looking at virtual firms as an example of one of those. So it's enabled us to see what is out there, to look at firms of varying size, and to see what is the appropriate way of supervising these firms. The engagement has taken the form of discussing with firms their governance, approach to risk and compliance, and it's been seen very much as a two-way process, with firms debating issues with us, with a view to coming to common agreement on the way forward. The feedback so far has been encouraging, with firms appreciating the two-way nature of the contact, as well as appreciating the desire of the SRA to get to know their firms. But I think I ought to move on from the pilot whilst there's no firm decision been made as to the exact nature of relationship management going further on from the pilot, the basis of it will be this, and that is that the firms will have a named person within the SRA who can act as a contact with that firm, discuss any problems that come up whilst they're there, if further work is needed from other departments within the SRA, to go out and find those people to do the work, and in other words, to tailor a system that is appropriate to one particular firm. Now, I'd like to move on now to medium impact firms. Now, again, this has been subject to a pilot, and that is running a little bit longer to September 2011. And firms that fall within the medium category will be supervised using a combination of desk-based reviews as well as on-site visits. Now, the use of desk-based supervision and on-site visits is not going to be as intensive as was the high-risk relationship management, but it is likely that you will still have a named contact within the SRA supervision department, albeit that you may not see them as regularly as you will see the relationship management. But it will also be, the supervision process will be driven by events that have occurred, but may also arise from emerging themes. And I'd point out by example that such things as conveyancing could be seen as one such theme. And I should point out that any such supervision tool will be targeted and not a generic see what we can find wrong approach. Again, that is another criticism from the old system that we were seen to be going in to try and find what we can find. Now, as with relationship management, a successful pilot has been in place, and we have covered such specific events in the supervision in medium impact as supervising an orderly wind down of a practice and approach the theme of financial stability. I should also point out that we've also covered, going back to one in relationship management, we've also taken a look, apart from the pilot firms, we've also had a look at things like outsourcing. This has been a particular area that, does it represent a risk to the SRA? Well, how do we know until we get out and do that? So the relationship management team have been out talking to firms who either have done it or are going through that process to see exactly how it works and to formulate an opinion, is it a risk or is it not? Okay, the final the rating is low impact. As the category suggests, firms are classed as low impact. They don't constitute any material threat to the SRA's regulatory objectives. However, this does not mean that they will be totally disregarded for supervision purposes. As with medium impact firms, they will be subject to periodic desk-based supervision and on-site visits, concentrating on both events and themes. Now, this is a case where random visits may occur. Again, at the moment, this is very much in the preparation side, but that is where we are at the present. So, should a firm show no willingness to cooperate with the SRA supervisory process, or a serious event does take place, then supervision will be handing over to enforcement. I therefore hand over to Andy Donovan, a legal advisor within the SRA, who's going to talk to you about enforcement.
Thanks very much, Martin. As Martin says, I'm Andy. I currently work in the legal team as a legal advisor. I'm going to give you a quick overview of what enforcement is going to look like in the outcomes-focused world. This first slide just summarises the key principles of outcomes-focused enforcement. The first thing to stress is that outcomes-focused regulation does not mean light touch regulation. Deterrence against other future misconduct and protection of the public interest must still be and is still at the heart of what the SRA does in terms of its enforcement role. Enforcement action should always be effective, proportionate and fair. Proportionality in particular does underpin the new approach, and the new outcomes-focused code will allow us to take that proportionate approach in terms of the practical assessment of compliance and what steps to take from there if there's any issues. Transparency as well, that is at the heart of our approach. This is an area where the SRA has made quite a bit of progress in recent years. On the website now, practitioners can find a great deal of information about how the SRA investigates matters and what regulated persons can expect from an investigation and from enforcement action, including quite a lot of information about our decision-making criteria and how we reach particular decisions and why. Accountability, this is also key. There is a comprehensive suite of internal and external appeals in respect of any enforcement decision, disciplinary decision, which is made by the SRA, and that will apply equally for traditional law firms as well as for alternative business structures from October. If we just move on to the next slide, those principles are set out. They form the heart of the enforcement strategy, which is available on the SRA website, and you've got the link there on the slide. A key part of that enforcement strategy is constructive engagement, and as Martin says, this is essentially where firms work with us, which we encourage to put things right, unless there are very serious issues arising, then for the most part it's anticipated that they can be dealt with through that supervisory, through that engagement approach, rather than matters being referred on for formal enforcement action, for disciplinary action. Okay, so that's all I want to say on that slide. We just move on. In terms of what enforcement action is going to look like, this slide just summarises the key enforcement tools which are available to the SRA. In traditional law firms and ABSs in the future, we will still be able to obtain under our statutory powers information and documentation files relating to a conduct investigation. And if necessary, that can be enforced by a court order. We would still be able to impose conditions upon solicitors' practicing certificates. We will also be able to impose conditions upon significant ownership interests, non-lawyer ownership interests, should I say, in terms of alternative business structures. And increasingly, we'll be looking to impose conditions where appropriate, where proportionate, in terms of an entity, a firm's authorization, commonly where there are concerns to restrict that entity from undertaking a particular activity. A new tool which has been developing within the SRA and is already being used is regulatory settlement agreements. This is essentially where the where there can be some quite serious issues involved, but rather than the matter going to the tribunal, by virtue of the fact that the firm engages with us, accepts that there is a problem, and takes mitigating steps to put things right, such as reimbursing clients for any monies that have been lost as a result of the misconduct. Often that is a better outcome for the consumer, and it is possible to deal with the matter by way of agreement rather than referring it to the tribunal. Disciplinary sanctions, I'll talk about those in a bit more detail in just a moment, but essentially where appropriate we will still rebuke firms. There will still be powers to fine and remove individuals and indeed firms from practice. Intervention, this is another key enforcement tool, very serious and very important tool, which can be exercised in the public interest. It's commonly exercised where there's reason to suspect dishonesty, and involves the SRA going into the firm, seizing papers, freezing client accounts, and effectively bringing the firm to an end. So if we just move on now to look at the enforcement against firms slide. The first point to note is that in terms of creating our new regulatory disciplinary approach, the new disciplinary procedure rules where appropriate, where possible, where permitted by the new statutory regimes, do set out a consistent and fair approach for regulation, as Anthony mentioned earlier, in terms of the approach between traditional law firms and ABSs. One example here is, for example, the rules adopt the same approach for written rebukes and publication of written rebukes in respect of ABSs as we currently do for traditional law firms. Moving on to fines, the first point to note in the future is that in terms of ABSs, the SRA will be making all disciplinary and regulatory first instance decisions. So the SRA will have the power, as is proposed, to fine an individual who's involved in an ABS up to £50 million, and the ABS itself up to £250 million, with appeals against those decisions going to the tribunal as appellate body. In terms of traditional law firms, the SRA will still be able to fine, and should I say those involved in traditional law firms, the SRA will still be able to fine up to £2,000, and thereafter, with referrals to the tribunal, there is a power to levy an unlimited fine. Okay. In terms of disqualification, this is a new power which the SRA will have in terms of alternative business structures to disqualify a person, an individual or an entity from holding a specific role within an ABS, and the tribunal will still exercise its power in terms of strike-off Section 43 orders for non-lawyers and suspension as well. Control of ownership for ABSs. It's worth mentioning that under the Legal Services Act, the SRA does have quite significant powers to regulate material restricted interests held by non-lawyers in terms of alternative business structures. Okay, that's all that I want to say about enforcement. I just finally pull together for you this example which draws upon risk, supervision and enforcement talked about in this part of the webinar. So the scenario given here is that you are the senior partner in a 10-partner firm. The cashier comes to tell you that he has uncovered substantial unexplained withdrawals from the client account by one of the junior partners of the firm. You begin an investigation which reveals that the junior partner has been making round sum transfers to his personal account and disguising them by creating and submitting false bills. You suspend the partner immediately, you report the matter to the SRA and also to the police. So drawing together these three elements which we've talked about, the risk centre has already assessed the firm as low impact, but the event obviously as a high risk. Supervision is informed of the event and decides that it's appropriate to visit the firm. Having done so, supervision establishes that the firm has suspended the partner already and investigated the matter and replaced the monies in question in full. However, the supervisor does note that there are some problems in terms of the firm's file audit procedures. So in terms of the outcomes of these matters, the supervisor works with the firm, engages with the firm to introduce a system of file audits and agrees that as part of a compliance plan to put those issues right. The junior partner's conduct, however, being that much more serious, is referred to the enforcement team at the SRA. The enforcement function duly institutes disciplinary proceedings in respect of the individual junior partner, and at the tribunal he is found to have acted dishonestly and is struck off. Okay, so I hope that's helpful in terms of bringing those three elements together for this part of the webinar. I believe we're now going to move on to take some questions from any part of the matters which we've talked through.
That concludes today's presentations, and we are now about to begin our question and answer session. I'd like to remind you that in order for you to claim your attendance at an accredited CPD course, we do need you to remain with us until the end of the Q&A session. You can now begin or continue to submit text questions and comments using the box provided on screen. Alternatively, to ask a question and make a comment by telephone, if you've not already dialed in, please dial 0203 159 9716 and type "I want to ask a question by telephone" into the Q&A box and stand by to be introduced by the operator. I'll now hand you back to the presenters.
Thank you very much. Now, let's see. We've got a question in on, to do with colts and coppers. Now, the questioner asks, will the colt and copper, will they become scapegoats for compliance failures within a firm? Now, well, the answer is absolutely not. Compliance officer roles are positions of responsibility, and the colt and copper must take all reasonable steps to ensure that the firm complies with the terms and conditions of its authorization. However, ultimate responsibility, as I think we did emphasize in the talk, ultimate responsibility still lies with the firm and its managers. And this is made very, very clear, and I believe it's 8.2, I think, in the authorization rules. So ultimate responsibility lies with the managers, but the colt and copper roles are crucial to OFR, and they will act as a point of contact between us and you.
Yes, I've got a question that's been asked, and it's with regards to risk and the scoring of risk. It's a double-headed question, but basically the question is, will the firms be told what their risk scores are, and what does it mean if a firm is high risk? Well, no, there are no plans at present to publish the scores and the ratings, etc. But I think the firms will find out, certainly if they are assessed as high risk, then they will be receiving notification of a relationship management or engagement. What does it mean if a firm is high risk? Well, it doesn't mean that you are a bad firm. What it means is that the size of the firm or the amount of money that you are holding from the regulatory perspective of the SRA is a high risk. It doesn't mean that you as a firm are bad. So it's the type of supervision it receives is what the reasoning behind the high risk, and is not a measure of quality of that firm.
Thanks, Martin. Now we've got one about Lexel accreditation, and the question is, what role does Lexel accreditation have in the new regime? Now, well, obviously, Lexel accreditation is a very impressive accreditation, and no doubt it will help firms provide the proper service to clients and ensure that their internal systems are appropriate. Now, so just because the SRA is changing its approach to regulation doesn't mean that Lexel necessarily comes redundant or anything of that sort. But I think it's properly run firms and Lexel accredited firms will complement each other. So I think Lexel continues, but obviously this is not something which is run by the SRA. So has anyone else got a comment on that on the panel?
No, I think you
very good answer. Okay, so now I think we have another question.
Yes, it's Anne here. I have a couple of questions which relate to ABS. A very quick question about when the ABS application form will be available. We are, as an organisation, we've developed an online application, and it cannot be published until we are designated as the licensing authority. So we are aiming for an August date with regard to that application form. And I also have another question here about what the definition of material for the purposes of material failure. Well, in respect of that, it is really for the compliance officers of the firm to determine what a material failure is based on the context of the firm that they are in. The compliance officer must report to the SRA any failure to comply which is a material failure, whether it's taken on its own or as part of a pattern of failures. But what I would do is refer you to Rule 8 of our authorisation rules, and in particular the guidance notes associated with that Rule 8. Guidance note number 10 goes into quite some detail on what we define as a material failure.
Okay.
Andy, I think Andy.
I've got a question here. Thanks, Nikki. How will the SRA be exercising its new disciplinary powers regarding alternative business structures? Which is a very, very good question. I went through some of the new powers, quite significant powers, which the SRA will have in terms of disciplinary action in respect of alternative business structures. The SRA's adjudication team will continue to be the function responsible for such decision making. It will remain separate to the investigatory side of it, so adjudicators will not be involved in the investigation in any way. We've set out within the disciplinary procedure rules, for example, new financial penalty criteria, which will govern how this greater power will be exercised. We've also set out some disqualification criteria within those rules as well. So that also gives more detail about how the SRA will be exercising these new powers. The other point to note as well is that our application to become a regulator of ABSs was made on the basis of the Solicitors Disciplinary Tribunal taking on the role as an appellate body in respect of any decisions which we do make, such as those I've just described, in respect of alternative business structures, as well as a number of authorisation decisions about ABSs. So just to note that whilst the SRA will be undertaking those first instance decision making, there will be an external appellate body, a familiar external appellate body, which will be the tribunal.
I've got a couple of questions that have come in. But first of all, I think this is from somebody called Neil. In the first presentation, I missed the name of the SRA book recommended for purchase, not the handbook. Well, Neil, actually, it's the Outcomes Focused Regulation at a Glance, and you won't need to go out and part with your money. If you go onto the website, the Freedom in Practice, you'll find a downloadable version of it. It is an extremely good book and does give you a very comprehensive look at all the elements that we've been talking about today. The other question that I've got here is what level of accountancy experience would you require offer in a small practice? I think the most important thing is that the person who does take on that responsibility does not have to be a chartered accountant or whatever, but needs to have a good understanding of the financial systems that are taking place in that firm. If it is a partner, they should be able to look regularly at reconciliations, etc., regularly understand from the staff who are undertaking the financial functions what is going on and if any problems have arisen, so that they can, for themselves, be able to make a judgment as to whether it is something that should be reported to us.
Thanks, there, Martin. Anne?
I have a couple of questions here. What would be the situation if the firm tried to prevent a culp from reporting a breach? Well, I'll have a go at starting this off, but I think maybe my supervision and policy colleagues might have some comments as well on this. In respect of a firm preventing a culp from reporting a breach, then the compliance officer does have a responsibility to report to the SRA, and therefore it is incumbent on them, if they feel that the issue is a material breach and should be reported, it should be reported to the SRA. And any prevention by the firm of them being able to report would also be a material issue, I believe, from our perspective, and would be reportable.
I agree, Anne, and I think we could be talking about really quite serious breaches of the principles.
Yes.
And I think we would view that sort of behaviour as something which would, Andy, I don't know whether you'd like to say anything possibly about the approach enforcement might take to this, but I think that applying pressure on your cold or copper not to report this sort of thing, it would undermine the system, and I think we would take appropriate action. Andy would.
Yeah, no, I agree. I think we'd be inclined to take something like that very seriously. It cuts across the intention set out in the handbook and goes against the principles, which, as Nikki said, are at the core of what we do. It is there for a reason, a very good reason. So I think we'd take such sort of overt attempts to put a hurdle in the way of those reporting requirements quite very seriously.
I also have a follow-up question here. If an employee is a COP or under COFA or a COFA, would he not be intimidated by the senior partners if they're only an employee and therefore unable to carry out his or her duty diligently? I think it is incumbent, and I'd like to stress this point, it is incumbent on the firm when they are appointing the COP and the COFA to ensure that the individuals have sufficient seniority and sufficient influencing abilities to be able to influence the partners, and that if they are an employee and not a senior partner within the firm, then the senior partners should ensure that the culture allows those individuals to fulfil their obligations appropriately. And if we, through our supervision visits or through reporting, were to find that the culture wasn't of that type, then we would obviously start to have discussions with the senior management of that organisation, whether they be an ABS or a recognised body. And if a compliance officer was concerned about that, again, I think it comes back to the earlier point that we would expect those compliance officers to be coming to us to express their concerns in them not being able to fulfil their roles fully.
Yes, and I think it's probably worth repeating that it may well engage the principal, the possible breach of the principal, by the principals of the firm.
Yes.
And this could be dealt with really quite severely.
Yes.
Okay. I've got a question here. I can't necessarily answer it.
Never mind.
I'll read that. Jane has asked, how should professional indemnity insurers approach insuring ABSs? And specifically, will they insure the entity to include the non-lawyer part of the business, where other professionals are involved? Now, my understanding of this is, Nikki will correct me if I'm wrong.
Go on,
but is that essentially the insurers will be insuring the law side of it. I mean, it's
legal
quite,
activities.
Yeah, it's quite complicated, isn't it? The definition, but essentially it's the reserved activities and the other legal activities, and anything else which the ABS by the SRA is regulated to do. It's not going to be expected to cover. And I think our rules are quite specific on this.
Yes, that's right. So
the other services beyond that regulated entity.
Yeah, I absolutely agree with you, Andy.
That's a relief.
Oh, well, there we are. So now, I've got a couple of questions here on a slightly different topic now, but we did mention it in the presentation. Referral fees. Now, referral fees are pretty topical at the moment. We've seen the Jackson report, and we've seen the draft. The draft bill, and there's been quite a lot in the media about them. So one of the questions is it my responsibility to ensure that an introducer is behaving properly? Now, I think our very firm answer, both under the old regime and under the new regime, is absolutely yes. You shouldn't enter into or continue with an arrangement which prejudices the interests of clients referred to you under that arrangement. So if the introducer's publicity is misleading or the client's being treated unfairly, you should take the matter up with the introducer, and if you do have these kind of concerns, you may need to terminate your arrangement with the introducer. Now, also on referrals, we've got a second question, and it's about referrals between lawyers. The answer is under the new under the OFR approach in the new code, that referrals between lawyers are treated just like any other referral, and there should be transparency for clients. Transparency is the terribly, terribly important thing, and clients' best interest.
Yeah.
So I think that deals with that. Now, Martin, what have you got on there?
One very specific to relationship management that has come in from Andrew. His question is, I believe that relationship management involves close and continuous supervision. In practice, how much contact between SRA and the firm could a high-impact top 100 with no special issues or changes in prospects expect? Well, I think, first of all, what we've experienced so far in the pilot is that the first, once a manager has been allocated to a firm, that is to get to know that firm. And so far what we've been doing is getting to know the governance and systems of firms, and we start to understand how a particular firm ticks. Now, if there are no issues, then what we're envisaging at the moment is that there may be meetings or telephone calls monthly with that firm to discuss how things are going along, whether there are any issues. But for instance, if for instance the SRA received a complaint or another issue did crop up, the relationship manager would be able to get in touch with the firm and to discuss through the issues arising out of any complaint, and if there are any adjustments needed within the firm to make sure these complaints didn't happen again, then the manager would oversee that just to see that these processes are taken into place. I think what the other main important thing is that this is going to be a two-way exercise between the management, the relationship between the manager and the firm. What we would hope is that the firm, once this relationship is in stone, that what you would get is a two-way process where the firm are quite happy to pick the phone up to the relationship manager and say, listen, this is an issue that is coming up. What do you think about it? What does the SRA think about it? Or can you tell me how I can get some more information about it? So that's how I see it happening. Now, there's just one other question that I think is a very quick one that has come through, and I think you can answer very quickly, and it's to do with coffers again. And it says, I understand that a coffer must be a member or employed by the authorised body, but is it possible for a coffer to be employed by more than one authorised body? I think the issue must be is that the coffer must be able to demonstrate, A, that they have the requisite knowledge to be able to take that post on, but also to devote the time to each of these individual authorised bodies. So I think that is the issue, but I think modern, if you're talking about a consultant doing 2 or 3 days in one firm and 2 days at another firm, I think with modern communication systems, as long as you demonstrate that that person is well in touch with each of those firms, then I don't see that there will be a problem with that person as long as they are qualified. But my colleagues here are going to jump in now.
Well, not sort of jumping in, but I think one issue which has come up before is could the function of Colson Coffer be outsourced? Well, the answer to that is very much absolutely it cannot be outsourced. The person acting as Colson Coffer must be part of the firm concerned. So it's not a question of shipping out responsibility to for fulfilling the role to an outside organisation.
So a firm of chartered accountants who do the reporting account can't be the coffer.
That's absolutely right. Anyone else got any views on that around the table today?
No. I do have a question though for Amanda. Joan has asked how will the SRA ensure a sole practitioner who is both the colf and the coffer complies with his or her duties?
Well, I think the answer to that must be through the supervisory approach that's applied to the firm, and whether or not there are any notification requirements clauses in the rules, of course. but very much our approach is going to be driven by risk and by the impact scores that I was talking about earlier, and so the extent to which you have interaction with the supervision function will obviously vary. I've got a question also that relates to supervision, which is, will you be doing random audits to check that firms are complying, i.e. with the supervision and the rules in the handbook? Well, I think as the presentation said earlier, random audits and random visits are very much part of what's regarded as a good way of supervising. So, in essence, I think the answer is yes. We think that's important for a variety of reasons, and one of them is to make sure that we are able to test our risk approach, make sure that it's directed in the appropriate places, which will help us reduce our own operational risks, and will also make sure that we can pick up on any new or emerging risks that may be present in certain sectors of the legal sector.
Thanks, Amanda. Now, back to our favourite topic again. This time, I think it comes from Amit, if I can read the writing properly, and it's about sole practice and the subject of Kolb and Copper. How would an individual working as a sole practitioner abide by the rules concerning Kolb and Copper? And does he need to employ further people, or is it's not applicable to him? Well, it is very much applicable to sole practitioners, the need to appoint a Kolb and a Copper. But I think, as we've been at pains to explain, OFR is all about flexibility, the right outcomes for clients and for your own particular business. So we fully anticipate that sole practitioners will be able to comply with these requirements. Now, in the case of sole practice, and of course we must remember that sole practice has a whole variety of possible models, from the single fee earner right through to a large business involving many fee earners and involving quite a big, a substantial turnover. So it is absolutely right, for all the reasons we've set out about client protection, that the requirements should go all the way across the board, including sole practitioners. But I don't think the smaller sole practice should be particularly concerned about the requirement, and the answer is very much no, you don't have to take on somebody else. The role of Kolb and Copper can be combined into one person, and that person may be the sole practitioner, and so everything would be concentrated on that person, or it can be, the function can be delegated to an employee. But as Anne has been telling us, it is obviously terribly important that the employee is given the appropriate authority and is not lent on and to prevent the person holding the role from reporting issues that should be reported to the SRA. Does anybody else want to make any particular point about the smaller firms and our regulatory approach?
No, but we do have a specific query here about which may have stemmed from a similar concern. It's to do with the compliance plan, which I referred to in the example towards the end of my talk. I think there was just some concern about what exactly the compliance plan was and if it involved additional work, essentially. Martin, my understanding is that that's a supervisory tool. Is that right? Where there's been a problem, and where the SRA engages with the firm and concludes that, provided the firm take appropriate steps and those are agreed in the plan, that it's not necessary to refer the matter on to...
That's correct, and I think what will happen is, whether it's by relationship management or by a desk-based supervisor, what will happen is that person will talk to the firm about whatever breach has taken place, discuss with them how it has arisen, suggest, what have you, ideas for rectifying the system so that error can't take place in the future, and then putting into place making sure that the firm puts into place these procedures to eliminate these errors, and to take a view and say, well, come back in a month's time, I'll come back, and just to make sure that that is happening. It's nothing more than that, a compliance plan. It's not a detailed, unless there are a lot of problems, but no, the main thing, it would be a simple plan, a simple agreement between the parties to say, but by this date, this will have happened, to make sure that that doesn't happen again.
Okay.
Thanks, Martin. We've got a question in here about Colts and Coffers. And it's in connection with a subject perhaps we haven't covered very much today. And the question is an in-house lawyer, do they have to have to appoint a Colt and a Coffer? Well, the answer to that is no. Obviously, our code applies to in-house practice just as it does, and has generally in-house practice just as it does to private practice. But there are different considerations for in-house practice, and no, there is no requirement to appoint a Colt and a Coffer. Another question, Anne, over to Anne.
Yes, I have another question with regard to Colts and Coffers, asked by Jane. Do firms deputy Colt and Coffer, i.e. the people who will cover for the Colt and Coffer when they are absent, also need to be authorised by the SRA? I think our regime appreciates that people are entitled to occasionally go on holiday. Some employers may be more in favour of that than others, but we do recognise that people will take a week or so's annual leave through the year. And there is no need to have somebody authorised to cover for them. In fact, it is worth noting that the firm can only have one Colt and one Coffer. It may be the same person, but there's only one authorised roll holder in each of those posts. What there are in the rules are circumstances that we also appreciate may occur if your Colt and your Coffer or your Coffer leaves. Whether they leave as a planned exit or whether it's a sudden exit, there are temporary emergency recognition procedures within the authorisation rules which a firm would need to follow, and we would need to be notified of that quite promptly, and we also need to ensure that a replacement Colt or Coffer is found for that post and authorised quite quickly.
I think a question has come in that is talking about the risk register, and I understand that we will now be expected to maintain one. Well, what we've been doing as part of the relationship management project is to have a look at firms, and the firms we've been to, the larger firms have tended already to have a risk register in place, and it's interesting to see the different ways that these are carried out. But I think it is fundamental within the new handbook and within OFR as general that risk is a basis that of the new way forward for supervision and regulation of the profession. I think it really is important for all firms, no matter what size they are, to give consideration to a risk register. Now, it doesn't have to be a formal one. There is no set standards for risk registers. So before anybody comes on and says, can you tell me where to get a typical example, there is no such typical example. But I think what you need to do is to identify the risks to your practice. When you've got that, when you've identified the principles, the risks that you have, identify just how important they are to your firm, and also put to it anything that will mitigate those, anything you have in place, any systems, and therefore, what your way forward is. I'm now being told that there's a question to come through.
Okay, well, one final question here.
The final question we're being told is the one's just come through about a public sector legal team for quick discussion, which is essentially how the ABS regime will accommodate the public legal sector team if it were to move into private practice and be owned by the local authority its primary client being the local authority, but potentially other bodies and other members of the public being its clients. We're invited for our comments and views on how the SRA would approach something on those.
Well, I mean, it's Anne Morgan here. I mean, we have spoken to a number of public sector legal teams who are considering applying for an ABS licence, and essentially we would view them as any other firm who wishes to be licensed as an alternative business structure. The grouping would need to set themselves up as a separate entity. The local authorities, they were in this example, would be the majority owner of the practice. Then they need to arrange and understand exactly how the ownership structure is going to be set up and make their application accordingly. The non-lawyer element of the ownership is satisfied by the local authority, and then if any of the lawyers want to also take ownership stakes in the organisation, that could also be facilitated under ABS. So certainly the ABS structure very much lends itself to public sector departments, legal departments wanting to set up as separate organisations and offer legal services outside of their local authority.
Great.
Okay, and I think that is the final question that we have time to answer today. I think as a group, we'd like to thank you all for participating in today's webinar and for the plethora of very interesting and varied questions that we've had. It probably is to me to say thank you to you and to the presenters here, to Andy, Amanda, Martin, Nikki and myself, and goodbye. Goodbye.
Thank you very much. Goodbye.